Good afternoon. Hi, so before we begin, I'm going to make two brief announcements. One, please make sure that you sign the sign-in sheet that is circulating. This is part of how we get our funding to get fantastic speakers. And two, this evening, so you can leave this talk and head over to another radical historians talk in Dwinelle, 155, Ilan Pape, who's a prominent historian, radical historian of the Palestinian-Israeli conflict and the occupation, is going to be speaking in Dwinelle 115 from 7 to 9 p.m. and food will be served. What is it? 155, excuse me. Okay, so hello, my name is Vina Dubal. I am a PhD candidate here in the Jurisprudence and Social Policy program, the law school. On behalf of the Institute for the Study of Societal Issues, I welcome you to today's talk by Professor Kelly Lytle Hernandez, entitled Not Imprisonment in a Legal Sense, the Invention of Immigration Detention, 1892 to 1896. Before I introduce our esteemed guest and her eminent respondent, Professor Leti Volpp, I want to tell you about the Graduate Fellows Program at the Center for Research on Social Change, which is responsible for organizing today's talk. For over 40 years, UC Berkeley graduate students across disciplines who are engaged in research on issues of inequality and social change have benefited from the professional training, mentorship, and financial support provided by the Graduate Fellows Program. I have been honored and privileged to be a part of the 2012 to 2014 cohort of graduate fellows at the center. We, under the mentorship of Dr. Christine Trost, Dr. Deborah Lustig, and Dr. David Minkus, have invited Professor Lytle Hernandez because we are collectively captivated by the importance of her work on the historical origins of one of today's most pressing social issues, the criminalization of immigration. The number and diversity of today's co-sponsors speak to the importance and reach of Professor Lytle Hernandez's work for social change scholars across disciplines. Sponsoring departments and centers include the Thelton Henderson Center for Social Justice, the Center for Law and Society, the Carceral Geography's Course Thread, Graduate Students de la Raza, Ethnic Studies Department, Department of History, Department of Sociology, and the Interdisciplinary Immigration Workshop. Professor Kelly Lytle Hernandez is Associate Professor in the UCLA Department of History and Director of the UCLA Department of History's Public History Initiative. Her research interests are in 20th century US history with a concentration on race, migration, and police and prison systems in the American West and US-Mexico borderlands. Her book, Migra, A History of the U.S. Border Patrol, won the 2010 Clements Prize and is the first book to tell the story of how and why the U.S. Border Patrol concentrates its resources upon policing unsanctioned Mexican immigration, despite the many possible targets and strategies of U.S. migration control. In today's talk, Professor Lytle Hernandez will be talking about her new work, which explores the origins of immigration detention as a practice of human confinement that operates in a legal sense, separate and apart from imprisonment, but in everyday practice fills the nation's jails, prisons, and detention facilities. Professor Lytle Hernandez's talk will be followed by a response from Professor Leti Volpp, whose distinguished reputation precludes the need for an introduction. For the few of you who do not know Professor Volpp and her work, she is the Robert D. and Leslie K. Raven Professor of Law and Access to Justice here at Boalt Hall. Professor Volpp is a well-known scholar in law and the humanities and writes about citizen, migration, culture, and identity, and therefore is the perfect person to respond. We thank you for doing this. Professor Volpp's response will be followed by a Q&A period. So without further ado, please welcome Professor Kelly Lytle Hernandez.
Hello. Thank you for that, Vina. I just want to thank Vina and Professor Trost for inviting me to be here with you all today. We just had a wonderful lunch with the fellows and had a wide-ranging conversation about the academy and radical scholarship. I want to thank Leti for giving the comments because this is very much a work in progress. So I'm going to use everything that you say today to hopefully make this a better piece of scholarship for the work that I do in the public realm. Now, what I am going to do today is share a piece of the current book project that I'm working on. So I want to tell you a little bit about that before I get started. What I'm working on is an analysis and exploration of the rise of mass incarceration in the American West and in the borderlands. I don't think we really have a grasp, historically speaking, on why so many people are in cages in California and Arizona, New Mexico, and Texas. That the Southern narrative and the Northern narrative is quite clear to us, that the legacies of slavery in particular have played an incredibly important role of structuring incarceration in the South and in the urban North as well. But the Western story is a little bit different. So the American West has long been understood as the nation's frontier of freedom, right? Where the individual comes and forges democracy for the nation. Now, as radical scholars, we probably have a very different approach to the West, but that is still very much the popular understanding of this place where we are today. So I want to explore in this book how the West became this place of human confinement. So that is really what is the context for this piece today. Also, I'm going to really tell you a story today. And then we can talk about the historiographical interventions, the conceptual frameworks, and the analytical interventions. But I want to tell you the story first, because it's very much a little-known story and a very important one that we need to get out into the public realm. So let us begin. Immigrant detention represents the single largest and fastest-growing system of human caging by the United States federal government today. The ACLU reports that in 2011, the Department of Homeland Security held 429,000 immigrants in over 250 facilities spread across the country. Thus, when scholars and activists discuss mass imprisonment, we often flag immigrant detention as a crucial dimension of the story. But according to a decision made more than 1 century ago by the United States Supreme Court, immigrant detention is not actually a form of imprisonment. Rather, it is an administrative process renting passage through the nation's carceral landscape. Non-citizens spend hours, days, weeks, months, and sometimes years locked behind bars. But that time in confinement does not formally register as a story of imprisonment within the United States. So what I want to do with my time here today is to track the socio-historical roots of immigrant detention as a unique form of human confinement embedded within the nation's prisons, jails, and lockdown facilities. Invented by the United States Supreme Court more than 1 century ago, immigrant detention is a carceral artifact from the age of Chinese exclusion. At the heart of Chinese exclusion was a racial fantasy, most dearly and violently held in the 19th century American West. Bent upon forging the nation's racial frontier, white settlers and workingmen pushed into the newly conquered region, hoping to exclude and, whenever possible, to punish and to remove immigrants, Chinese immigrants from the western United States. Their demands triggered an unprecedented carceral turn in U.S. immigration control. It's a carceral turn that remains with us today. However, against the settlers' campaign, Chinese immigrants rebelled, refusing to be locked out, to be kicked out, or to be singled out for repression in the United States. As Chinese immigrants boldly defied U.S. law, riots brewed from San Francisco to Shanghai, and warships sailed into the Pacific. So it was their protest that forced the United States Supreme Court to issue a set of sweeping and enduring decisions regarding the future of U.S. immigration control. It's the future with which we live today. Tucked into the margins of those decisions lay the invention of immigrant detention. The dramatic but little-known history of immigrant detention is what I want to share with you all today. It is a story that begins in the American West. So after the U.S.-Mexico War, Anglo-American settlers and workingmen pushed into the new American West. Believing that the bounty of the American West belonged first and foremost to Anglo-American men and their families, they tried to halt Chinese immigration to the region. During the gold rush, during the gold rush, they used vigilante violence, foreign miners' taxes, and discriminatory legislation to keep Chinese immigrants out of California's mines. After the gold rush, they unleashed what one historian describes as, quote, a reign of terror and a litany of hate against Chinese immigrants in town after town. So here's an image of Chinese immigrants coming into the West. But in town after town, white settlers set fire to Chinese homes and businesses and enlisted posses to drive Chinese residents beyond county limits. Still, in search of work, thousands of Chinese immigrants arrived each year. By 1880, nearly 110,000 Chinese persons resided in the United States. Now, it was an infinitesimally small portion of the Chinese population, but in the sparsely populated American West, and against the backdrop of Indian wars in the region, Chinese immigrants rapidly emerged as the largest non-white population in the West. Fearing that Chinese immigration could surge across the ocean to swallow the Anglo-American West, the nation's racial frontier, anti-Chinese organizers in the region demanded that Congress pass legislation to prohibit all Chinese immigrants from entering the country. But many in Congress balked at the Westerners' dreams of total Chinese exclusion. Hoping to ship both cotton and Christianity to China, US diplomats, merchants, and missionaries all supported maintaining open migration between the United States and Mexico, and China. Yet in the West, anti-Chinese organizers violently disagreed. From soapboxes and sandlocks, they stoked voters and mobs and vigilantes to the chant of "the Chinese must go." In 1882, they successfully pressed Congress to pass a more modified exclusion law, the Chinese Exclusion Act, which barred Chinese laborers from entering the country for 10 years. Quote, "If this law is strictly enforced," explained one of the law's advocates, "it will not be many years before the Chinese race will be extinct in the country." So this is more than just about labor. It is about the extinction of an outsider in the nation's racial frontier. Now, the Chinese Exclusion Act held the Chinese population in the United States steady for 10 years, barring its growth. But Westerners still demanded more when it came up for renewal. Claiming that tens of thousands of Chinese immigrants had snuck across the borders or used false documents to unlawfully enter the country since 1882, the Western advocates of Chinese exclusion demanded that more be done to curb and reverse unlawful entry. Now, they're making these claims against the United States Census Bureau, which says this isn't happening. It's really an incredible fantasy of unlawful entry. If Congress did not make what they called radical changes, as argued by US Representative Thomas Geary from Santa Rosa, California, Chinese immigration would never end. It would only rise and rise until Chinese settlement washed across the Anglo-American West, drowning the nation's racial frontier. So to achieve the total, quote, extinction of the Chinese population in the United States, Geary proposed a bill to register all Chinese laborers in the United States. Any Chinese laborer who could not prove that they had legally entered the United States prior to 1882, proof that could only come in the form of one white witness, they would be denied a certificate of legal residency. Unregistered Chinese laborers would then be subject to arrest, punished by up to 1 year of hard labor in prison, and then deported. Now, this was defined as necessarily repressive by its advocates and needlessly draconian by its opponents. Geary's proposal for radical changes marked a major turning point in US immigration law. Prior to the Geary Act, Congress had adopted legislation to prohibit certain groups from entering the United States. By 1891, Chinese laborers, all prostitutes, convicts, lunatics, idiots, contract laborers, and those, quote, liable to become public charges, were all categorically prohibited from entering the United States. All such persons were to be stopped at immigration stations, interrogated, and denied entry to the country. But the Geary Act is a pivot from the past. The Geary Act introduced a new system of arresting, imprisoning, and then deporting immigrants who unlawfully established residence in the country. So we often talk about the Chinese Exclusion Act as being really the most important law in immigration history. I think it's the Geary Act. This is where this carceral turn happens. Although nearly focused on Chinese laborers, the Geary Act broadened the basic framework of US immigration control. If Geary's proposals were adopted, what had begun as a project of immigrant exclusion at the nation's boundaries would take a carceral turn to include arrest, imprisonment, and deportation from within the country. Now, Geary's proposal incited a short but vigorous debate in the United States Congress. Representative Robert Hitt, a Republican from Illinois, led a spirited charge against the bill. As chairman of the powerful House Foreign Affairs Committee, Hitt warned that Geary's proposal would, quote, result in non-intercourse, breaking up our trade with China. But Hitt was also an old Republican stalwart. He had been a close friend to President Abraham Lincoln and served as Lincoln's personal stenographer during the famous Lincoln-Douglas debates. Hitt implored his colleagues to reject Geary's proposal as a measure of securing emancipation within the United States. as he said, "Never before in a free country was there such a system of tagging a man like a dog to be caught by the police and examined, and if his tag or collar is not all right, taken to the pound, or drowned, or shot. Never before," he warned, with the exception of the sad days of slavery. Now, many in Congress applauded Hitt's words, but a few hours of debate led Congress to pass the Geary Act of 1892. Chinese laborers then had 1 year to get their papers in order. Beginning May 6, 1893, any Chinese laborer who had failed to secure a certificate of residency would be subject to arrest, imprisonment, and then deportation. Chinese immigrants in the United States rebelled against the Geary Act. Led by the Chinese Six Companies, an influential federation of Chinese immigrant benevolent associations. They engaged in a massive civil disobedience campaign. The Geary Act argued the Chinese Six was a, quote, degrading and contemptible law that unfairly subjected them to undue criminalization, policing, arrest, imprisonment, and deportation. Promising legal assistance to any Chinese person who defied the law and boycotts and retribution to those who did not, the Chinese Six Companies instructed each and every Chinese immigrant residing in the United States to, quote, stand together. United, it promised, we can break this infamous law. Now, at their urging, 90% of Chinese laborers in the United States defied the Geary Act. They defied the Geary Act's registration requirement, and instead they pooled their money to hire some of the nation's most distinguished lawyers. Together, immigrants, the Chinese Six Companies, and lawyers, they challenged the constitutionality of the Geary Act. It was upon their campaign that the future of U.S. immigration control hinged. Would immigration control remain a project of exclusion at the nation's boundaries, or expand to include imprisonment and deportation from within the United States? To lead the national team, the national legal team, the Chinese Six Companies hired Joseph Choate, a distinguished New York-based attorney. Choate immediately organized a series of test cases that had swept across the federal courts in Louisiana and Michigan and New York, Washington, California. Chinese immigrants, accompanied by lawyers, submitted themselves for arrest, and Choate's legal team strategically contested the constitutionality of the new law. Now, as argued by Choate, the Geary Act was a murky legal development. I really want to take us back to this moment in time when deportation did not seem to be a legitimate practice of the United States government. That's what's happening in this moment. According to Choate, the United States Constitution neither details nor allocates a congressional authority to forcibly expel non-enemy aliens from the country. Further, the Geary Act sidestepped the Constitution by empowering federal judges to summarily issue criminal punishments, namely sentences of imprisonment and deportation, without due process, such as the right to a trial by jury. Confident that neither the congressional authority to deport nor the stripping of due process from criminal procedure would survive judicial review, lawyers for the Chinese Six advised Chinese immigrants across the country to defy the law. From New York City to New Orleans to San Francisco, Chinese immigrants refused to register, and instead, with their lawyers, they submitted themselves for arrest. By May of 1893, the country's prisons were full with Chinese rebels against the Geary Act. But also by May of 1893, Choate's strategy had worked. Federal judges had affirmed and struck different sections of the Geary Act, creating a patchwork of conflicting decisions and sowing confusion regarding the constitutionality of imprisoning and then deporting unlawful immigrants. Now, despite the confusion, the federal authorities in San Francisco announced plans to aggressively enforce the Geary Act. To complete the arrest, they planned to establish a 24-hour guard around San Francisco's Chinatown and conduct house-by-house inspections. The threat of mass arrests in San Francisco, home to the largest Chinese community in the United States, really stressed and strained U.S.-China relations to a breaking point. From Washington, D.C., the Chinese minister warned that if the Geary Act were enforced, the Chinese government would sever all relations with the United States. In response to this threat, the U.S. Department of War ordered gunboats to patrol the South China Seas. In California, the Chinese Council organized a mass work stoppage, and rumors circulated that Chinese immigrants were gathering guns to defend themselves, where federal authorities were to siege their communities. From across the Pacific, Christian missionaries in China reported that some Chinese officials had threatened to massacre all Americans in China if the Geary Act were enforced. But back in the American West, white workingmen and anti-Chinese organizers, they marched and they clamored for the law's quick enforcement. No one doubted that they would truly riot if the Geary Act were not enforced. Now, as these riots simmered and warships sailed, Choate and the Chinese Six turned to the United States Supreme Court to settle the legal disputes regarding the constitutionality of the Geary Act. Just days before enforcement was scheduled to begin, representatives of the Chinese Six, the Chinese Minister of the United States, the U.S. Solicitor General, they all traveled to Washington, D.C. to meet with Chief Justice Melvin Fuller of the United States Supreme Court. Chief Justice Fuller, they hoped, would delay the court's summer recess to hear a test case challenging the constitutionality of the Geary Act. Fuller agreed. He held the court over an emergency session to hear the court's very first deportation case. Now, the test case organized by Joseph Choate and the Chinese Six began in New York City. The lead litigant, Fong Yue Ting, had immigrated to the United States in 1879 and made his way to New York City, where he found work in the laundry business. Ting had arrived legally in the United States before the Chinese Exclusion Act began in 1882. But when Congress passed the Geary Act, he became a founding member of the Chinese Equal Rights League. Established to challenge the Geary Act, the Chinese Equal Rights League argued that compliance with the Geary Act would force, quote, respectable Chinese residents to wear badges of disgrace, end quote. Refusing to be, quote, tagged and branded as a whole lot of cattle for slaughter, end quote, the Chinese Equal Rights League has rallies and distributed pamphlets protesting the new law. Fong Yue Ting, a legal Chinese immigrant, but founding member of the Chinese Equal Rights League, refused to comply with the Geary Act's registration requirement. Instead, on the morning of May 6, 1893, Fong Yue Ting, along with Wong Quan and Li Zhou, walked to the offices of the U.S. Marshal in Manhattan and admitted to, quote, unlawfully residing within the United States. Awaiting their arrival was an attaché of the Chinese legation in Washington, D.C., the Chinese vice consul in New York City, a circuit court judge, and their lawyer, Joseph Choate. The U.S. Marshal arrested Quan, Zhou, and Ting. The circuit court judge ordered them deported. Choate appealed their case, arguing that the judge had issued a criminal punishment, deportation, without due process of law. 4 days later, and according to the plan, Choate argued U.S. v. Fong Yue Ting before the United States Supreme Court. What I find to be really interesting is that on the morning that Choate argued Fong Yue Ting, a crowd of journalists, lawyers, peace activists, and anti-Chinese Westerners all pushed into the courtroom. Deportation, they knew, was on trial, and they, quote, occupied every available foot of space to hear the arguments. From Los Angeles to New York City, the press promises this would be, quote, one of the greatest legal battles ever fought in the Supreme Court. If the United States Supreme Court sanctioned deportation as a legal practice, a new day would dawn in the Anglo-American West and across the nation of immigrants. After a half-century of riots, boycotts, pogroms, and restrictive laws, Chinese immigrants would finally be punished for their arrival and forced back across the Pacific. And the nation would have the mechanism to capture, punish, and expel all unlawful immigrants. But would imprisoning and deporting unlawful immigrants survive judicial review in the nation's final court of law? Now, standing before the United States Supreme Court, Choate launched a 13-point attack on the constitutionality of the Geary Act. Among the first arguments he made was the charge that the Geary Act violated the Fifth Amendment by empowering internal revenue collectors to alone determine a Chinese immigrant's lawful status without a jury trial. The Fifth Amendment, he argued, guaranteed all persons the right to a jury trial when charged with a crime, such as unlawful residence, and facing a criminal punishment, such as deportation. Immigration control suggested Choate had taken a carceral turn that demanded all the rights and protections of criminal proceedings within the United States. Next, he argued that deportation was a form of, quote, banishment, and charged that it was a, quote, brutal, inhuman, and unjust punishment, one too severe for the act of unlawfully residing in the United States. Deportation, he argued, was, quote, a cruel and unusual punishment that violated the Sixth Amendment of the United States. However, and this is really important, the boldest claim that Choate made that day was that he forwarded the idea that the congressional foray into deportation was at its core unconstitutional. As he stated before the United States Supreme Court, no power is given to Congress by the federal Constitution to remove friendly alien residents. Presenting a short history of early American law, he claimed that the framers of the federal Constitution had considered matters of banishment and expulsion, i.e. deportation, but routinely denied such power to executive authorities. Therefore, it was by careful and intentional omission that the framers of the Constitution affirmatively refused to create, delegate, or allocate any congressional authority to deport. Deportation, therefore, was beyond the scope of congressional power and thereby unconstitutional. With this final charge, Choate rested his case against the Geary Act. Now, the United States Supreme Court worked quickly to issue its ruling in Fong Yue Ting. Riots, pogroms, markets, and possibly war all hung in the balance. Without time to write a written report or prepare a written report, Justice Horace Gray delivered the decision from the bench. In the audience sat a crowd of journalists, senators, and even the U.S. Attorney General. Speaking in a series of what are called offhand remarks, Justice Gray delivered the court's ruling in a rather quiet tone. The crowd had to lean in, maintaining the utmost silence to catch every word. In a near whisper, Justice Gray explained that Congress holds the power to deport. Such power, he continued, was rooted in a ruling that the court had issued 3 years earlier in a case about immigrant exclusion. In that earlier case, U.S. v. Che Chan-ping of 1889, the United States Supreme Court had ruled that prohibiting immigrants from entering the country was an extension of sovereignty and thereby a realm of plenary power. Quote, the power of exclusion of foreigners is an incident of sovereignty belonging to the government of the United States, unquote. As an incident of sovereignty and thereby a realm of plenary power, the court had ruled that congressional authority over exclusion cannot be given away or restrained on behalf of anyone. The political department of our government is alone competent to act on the subject. That comes from Che Chan-ping. The United States Congress, in other words, held, quote, absolute and, quote, unqualified authority over any laws, practices, policies developed in the pursuit of immigrant exclusion. The Constitution, as held by the court in Che Chan-ping, did not apply to immigrant exclusion. So in the case of Fong Yue Ting, which is being argued, explained Justice Gray, the United States Supreme Court held that immigrant expulsion was so closely aligned with immigrant exclusion that it too fell within the realm of Congress's plenary power over matters relating to foreign relations and sovereignty. Quote, the right to exclude or expel all aliens or any class of aliens, absolutely or upon certain conditions in war and peace, be an inherent and inalienable right of every sovereign and independent nation, explained Justice Gray. As a matter of sovereignty and thereby plenary power, the court ruled that the judiciary had no authority to intervene in matters of excluding or expelling non-citizens from the country. As such, the congressional foray into deportation was constitutional and, as a matter of plenary power, totally insulated from judicial review. The court also disagreed with Choate's definition of deportation as a punishment. Quote, the order of deportation is not a punishment for crime, explained Justice Gray. It is but a method of enforcing the return to his own country of an alien who has not complied with the conditions of legal residence in the United States. Deportation, in other words, was nothing more than an administrative process. It was not a criminal sanction, but rather an administrative and summary proceeding of returning unauthorized immigrants to their country of origin. Defined as an administrative process, deportation proceedings were not subject to due process protections. Whether excluding immigrants at the nation's boundaries or arresting immigrants already present within the country, the United States Constitution simply did not apply to the processes and practices of U.S. immigration control. So to be clear, Gray emphasized that in regard to the process of identifying, arresting, detaining, and deporting non-citizens from the United States, he stated, quote, "The provisions of the Constitution securing the right to a trial by jury and prohibiting unreasonable searches and seizures and cruel and unusual punishments have no application." Now, upon hearing these words, Senator Volpp from Oregon leapt and shouted. Tapped across the wire, the news soon reached his constituents and the Geary Act's many supporters in the American West. They howled in the streets and they cheered at open-air meetings well into the night. In Los Angeles, city residents held a parade and blasted cannons to celebrate. Soon, Chinese immigrants would be forced back across the Pacific, they believed. But to others, the court's decision in Fong Yue Ting came as, quote, a surprise. By spring of 1893, popular sentiment outside of the American West had decisively turned against the Geary Act. Missionaries, corporations, merchants, diplomats, and civil rights activists all argued against the law. Deportation, they argued, threatened foreign relations and trade while assaulting the dignity and freedom of Chinese immigrants within the United States. It was generally hoped and expected that the law would find its death blow in the highest tribunal of the land, explained the Quaker and anti-war activist Benjamin Trueblood. Yet among those most shocked by the court's decision in Fong Yue Ting were three Supreme Court justices themselves. Chief Justice Fuller and Justices David Brewer and Stephen Field all issued scathing dissents. Categorically distinct from immigrant exclusion, which happened in the nation's boundaries, they argued, deportation was a process that unfolded wholly on U.S. soil. As such, deportation could not develop beyond the reach of the Constitution. The Constitution, roared Justice Brewer, has potency everywhere within the limits of our territory. The dissenters also disputed the majority's definition of deportation as a, quote, administrative process. Deportation is a punishment, wrote Justice Brewer. It involves first an arrest, a deprival of liberty, and second, a removal from home, from family, from business, from property. It needs no citation of authorities to support the proposition that deportation is a punishment. Everyone knows that to be forcibly taken away from home and family and friends and business and property and sent across the ocean to a distant land is punishment. Holding a punitive definition of deportation, Justice Brewer lectured the majority that according to the Fifth Amendment, punishment applies at trial. No person shall be deprived of life, liberty, or property without due process of law. Due process requires that a man be heard before he is condemned. But having defined immigration control to be an incident of sovereignty in foreign affairs and thereby plenary power, the majority opinion in Fong Yue Ting fell away from the Constitution, carrying with it the invention of deportation as a site of unchecked federal power within the United States. Now, with the Fong Yue Ting decision in their pocket, and I mean literally in their pocket, Western advocates of the Geary Act demanded its immediate enforcement. But the Geary Act could not be enforced without the enormous financial resources required to identify, arrest, detain, and deport unlawful Chinese immigrants. Estimates suggested that the costs relating to registration enforcement could reach upward of $6 million. But upon passing the Geary Act, Congress had appropriated just $50,000 for the law's enforcement. Representative Hitt and his fellow opponents of the law had quietly withheld sufficient funding to enforce the law. They rendered the Geary Act an unfunded mandate. So here's that quiet protest within Congress. With limited resources, federal authorities deported few Chinese immigrants under the Geary Act. Although the impact of the Geary Act was relatively limited, the Chinese Six continued its assault on what remained of the law. Fong Yue Ting, after all, had sanctioned the rise of deportation, but the United States Supreme Court had yet to rule on the issue of imprisoning immigrants prior to their deportation. In 1896, the same day that the court would issue its ruling of Plessy v. Ferguson, the court would issue its ruling on immigrant detention in the United States. The case began in the summer of 1892 when Wong Wing, Li Poi, Li Yu Tong, and Chan Hua Dong walked into the office of the U.S. Marshal in Detroit, Michigan, and with their lawyer in tow, admitted to unlawfully residing within the United States. They were among the first Chinese immigrants to protest the Geary Act. Without any dispute as to the men's unlawful status, a federal judge quickly sentenced the men to serve 60 days in the Detroit House of Corrections and then ordered them deported. Their lawyer, Frank Canfield, doggedly appealed the case, Wong Wing versus the United States, until it reached the United States Supreme Court of May of 1896. Unlike Fong Yue Ting, the Wong Wing case attracted little attention. No crowds filled the courtroom. No journalists chased the story. The American public hardly took note. From the vantage of 1896, Wong Wing probably seemed to be a case with limited potential impact upon U.S. society. By 1896, federal authorities had deported just a few hundred people, most of them actually Europeans. Deportation, it appeared, had been a deeply contested legal development that would not amount to much in everyday American life. So when Frank Canfield stood before the Supreme Court, he stood there nearly alone to argue his case against deportee imprisonment. Canfield used the court's ruling in Fong Yue Ting to methodically challenge deportee imprisonment. He began his argument with the well-established position that the United States Constitution guarantees due process to all persons subject to imprisonment in the United States. No person, regardless of immigration status, could be deprived of their liberty without the rights and protections guaranteed by the Constitution. Yet, he reminded the court, Fong Yue Ting had established deportation as a realm of, quote, unregulated and absolute executive authority. Unlike criminal trials, no rights, not the right to a trial by jury, no protection from cruel and unusual punishment, and no protection from unwarranted search and seizure, for example, were guaranteed to persons subject to deportation from the United States. Without due process, argued Canfield, it was unconstitutional to subject deportees to imprisonment in the United States. Agreeing with Canfield, the court's ruling in Wong Wing held that the 14th Amendment clearly guaranteed that, quote, no state shall deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Sanctioned as a realm of unbridled executive power, deportation was untethered from due process. Without due process, ruled the court, no person, including deportees, could be subject to imprisonment within the United States. But here's the twist. Rather than guarantee due process to deportees, the court ruled that Congress was prohibited from muddling its unrestricted authority to deport with the constitutionally bound practices of crime and punishment within the United States. Unlawful status, ruled the court, was, quote, not a crime. It was merely an administrative violation to be managed by summary deportation proceedings. No deportee, it followed, could be criminally punished, i.e., imprisoned, as a penalty for unlawful status. The court, therefore, abolished imprisonment as a measure of U.S. immigration control. The end of deportee imprisonment marked a crucial turning point on the road to mass incarceration in the United States. Since 1896, the United States federal government has deported more than 50 million people from the United States. According to Wong Wing, none of the nation's millions of deportees were imprisoned as a punishment for, quote, unlawfully residing within the United States. Wong Wing, therefore, jettisoned the rise of mass incarceration as a punitive parallel to mass deportation in the United States. However, most of the nation's 50 million deportees would spend time forcibly confined within one of the nation's carceral facilities. In the pursuit of deportation, federal authorities routinely confined deportees in jails, prisons, and immigration facilities during the, quote, long middle process between arrest and deportation. Awaiting immigration hearings and transportation arrangements, deportees can spend hours, days, weeks, months, and sometimes years in confinement. Deportees, in other words, could not be sentenced to prison as a punishment for crime, but the administrative process of their forced removal from the country routinely confines deportees within the nation's carceral facilities. If not a matter of crime and punishment, what was this new dimension of forced confinement emerging from within the nation's carceral landscape. The United States Supreme Court answered this question too in its Wong Wing decision. Written as an aside, buried within the decision, no arguments were heard on this issue. The court explained that incarcerating unlawful immigrants was nothing more than, quote, part of the means necessary, end quote, to effect an immigrant's forced removal from the country. In a legal sense, held the court, deportee confinement was a form of detention and not imprisonment. Unlawful immigrants, in other words, could be confined in jails, prisons, and immigration stations. In these days, they were also held in trains and in sheds. But the time behind bars would not register as a subject of imprisonment, nor be subject to the Constitution. Rather, detaining deportees was simply an administrative process renting passage through the nation's carceral facilities. Wong Wing, therefore, ended deportee imprisonment, but invented immigrant detention as an administrative process of human confinement. Now, set adrift from the Constitution, immigrants in detention and their lawyers have long contended with the complexities of confinement wrought by Wong Wing. If not protected by the Constitution, what are the rights of immigrants in detention? How long can they be detained? Under what conditions can they be confined? And what are their rights to representation? These are just a few of the questions that still crowd the courts and today drive a hunger strike in the Northwest Detention Center. But for me, a historian's job is to dig to the root. And what I've tried to lay before you all today is the socio-historical story of when, why, and how we as a nation came to cage unlawful immigrants in such a peculiar and exceptional way. Driven by a 19th century racial fantasy of the American West as the nation's racial frontier, the region's anti-Chinese organizers demanded that U.S. immigration control take a carceral turn toward imprisonment and deportation. Chinese immigrants across the country rebelled, forcing the Supreme Court to issue a series of sweeping and enduring decisions regarding the future of U.S. immigration control. Tucked into the margins of a decision abolishing deportee imprisonment, immigrant detention was born. Although Congress abolished Chinese exclusion during World War II, immigrant detention remains, dramatically shaping the story of human confinement in our time. A carceral artifact from our racial past, immigrant detention is now a vast but veiled dimension of mass imprisonment in the United States. Thank you.
So I want to thank Vina and Christine for inviting me to respond, and I want to thank Kelly Lytle Hernandez for the opportunity to engage with what's a really beautifully written and profoundly important work. There's much more actually to this paper that she doesn't have time to read to you today. I see many experts in carceral studies in the room, so I'm not going to take too long because I know there are a lot of people here wanting to engage. For those of us in the law school who learn and teach by reading cases, the work of the historian helps clarify that what became the law was not inevitable. While the justice's opinion appears and then becomes received wisdom, Kelly shows us the politics, the pressures, the texture of the moment leading up to and after the decision is issued. This forces us to rethink what happened, to shrug off the weight of history suggesting a linear path until now, a linear path which very early on told us that deportation is not punishment and that the detention of immigrants is not considered imprisonment. Kelly makes us think, well, what if history had taken a different turn? What she suggests in the paper is that Wong Wing paved in a non-obvious way the road to mass incarceration. And to explain how this is not obvious, she explains how Wong Wing gets conventionally received, which is actually often as a victory for immigrants, in that in Wong Wing, the Supreme Court held that aliens as persons could not be subject to imprisonment at hard labor without judicial trial for failure to register under the Geary Act. Yet this conventional view of Wong Wing is incomplete, for as Kelly and a few other legal scholars such as Dan Canstrom suggest, Wong Wing also said that detention or temporary confinement as part of the means necessary to give effect to the exclusion or expulsion of Chinese aliens poses no constitutional problem. With this rigid distinction now drawn between detention as part of a means necessary to effectuate removal and imprisonment, the Supreme Court created our present-day phenomena where immigration detention is generally conceived as separate and apart from prison. So Kelly aims to change this with her paper. She writes, quote, "This was the abolishment of deportee imprisonment as a crucial turning point on the road to mass incarceration," close quote. This statement raises many questions about what terms to use. Do we want to concede that this was the abolishment of deportee imprisonment? One way to articulate the issue would be to suggest that instead we might argue that this was a decisive moment in the divergence of fact and fiction, where we see the exercise of the legal sleight of hand, which simultaneously continued detainee imprisonment while denying that imprisonment was taking place through using the language and logic of detention, placing that imprisonment outside the realm of what could be challengeable. A second articulation of this moment relies more on parsing out the language in the opinion. The question involved is whether Chinese laborers living in the United States must either register with the federal government or be subject to arrest and up to 1 year's imprisonment at hard labor and thereafter removal from the United States. So the court in the opinion states that this inflicts an infamous punishment. The Fifth and Sixth Amendment of the Constitution declare that no person shall be held to answer for a capital or otherwise infamous crime unless on indictment of a grand jury and a speedy and public trial by jury. The opinion goes on to say that imprisonment at hard labor in the state prison or penitentiary is an infamous punishment and that it is involuntary servitude for crime forbidden by the 13th Amendment. So I think it would be worthwhile to trace here the historical relationship between infamous crimes, crimes punishable by hard labor, and felonies, and how those notions have coalesced and diverged and coalesced both in the Anglo-American tradition, in thinking about how the court here draws a distinction between what it calls detention or temporary confinement with this other category. The shadow of chattel slavery, the valorization of freedom to contract, seems important to the court's distinction between these two contexts, where the court is extending the protection of the Constitution to the alien and what would be their imprisonment at hard labor, but not for their mere detention. In other words, I'm not sure if it's just a distinction between detention and imprisonment or between detention and imprisonment at hard labor, and I don't know the answer to this question. A third articulation of this moment would fold it into a recent shift in studies of crime and punishment. So there's a new emphasis in criminology on misdemeanors, a new emphasis in carceral studies on jails, which we could perhaps think of as a shift in focus from the major to the minor which has not been the focus of historical study, but which has had and continues to have a tremendous impact both on persons and how we understand the phenomena of crime and punishment. How might not just naming immigration detention as imprisonment change the story, but actually centering that experience and how we understand the phenomena of imprisonment? For one, it would suggest that we need to trouble the bifurcation between criminal and civil in thinking about confinement, and thus fold into our study of the prison all forms of civil confinement. A fourth articulation, which is actually something that Kelly powerfully suggests in her paper, is that we need to rethink mass incarceration beyond crime and punishment, right? So how might it shift how we think about mass incarceration to do this? This is an important question, and it really begs the question of what kinds of terms and concepts we use. Do we say carceral studies? Do we say mass incarceration? Do we say cages? Do we say the camp? Like, what do each of these terms do and not do for us? Kelly's paper provides a lot of other food for thought, and because of time, I've had to cross out much of what I would say. But one thing I would ask is she describes what she calls this massive civil disobedience campaign, fascinating claim, which really seriously troubles the claims that some scholars make that 2006 mass mobilization marked the first social movement for immigrant rights in U.S. history. It also troubles the stereotype of the purported passivity of the Chinese immigrant. At the same time, I don't know if you said this orally, but in the paper we have to note that the Chinese Six, while promising legal assistance to those who disobeyed, also threatened retribution against those who did not. How does this actually shape whether we should think about this as civil disobedience? Another question to tease out is how the paper makes us think about how we study the history of racialization. So I don't think Kelly had a chance to say this, but there's a sort of strange and unexpected use of immigration detention after these events took place, where there's local attempts in Los Angeles by the sheriff who sort of single-handedly goes and has this unfunded mandate where he tries to deport all these people, but there's not this federal interest in doing so, and that when she looks at these statistics, in fact, most people in immigration detention after this period were European immigrants in the Northeast. So as she says, the anti-Chinese movement in the American West gave birth to the nation's first deportation system, but Chinese immigrants constituted few of the nation's first deportees, other than this attempt in Los Angeles. And she closes the paper actually with what she began here when she spoke, saying that these questions pull us to the US-Mexico borderlands, where the rise of Mexican deportation dominated the landscape of immigration detention. So this made me actually think about the Chinese in the story and how they function in stories of American history. So I was left with a little bit of a feeling like the way that the Chinese appear in the other major case decided on that day, Plessy versus Ferguson, where in Justice Harlan's dissent, he talks about the Chinese as a race so different from our own, we never allow them to become citizens, but they get to ride in the white car. Unlike African Americans, right? So it's like you see this kind of triangulation of racialization being created, and the Chinese sort of appear. And so the Chinese seem to appear as historically important, but not important now in relationship to a phenomenon that is not theirs now, right? It's a kind of queer orthogonal relationship to American history coming into view and then disappearing. And I think it's sort of interesting to think about that. To close, as Kelly said, immigration detention is now intensively both a mass phenomena and a site of legal contestation and protest, right? With in recent years, successful and unsuccessful challenges to indefinite detention, to categorical mandatory detention, so indefinite detention post-removal, categorical mandatory detention during this process when they're trying to figure out if the person is removable or not. And now in recent weeks, actually legal victories on the question of mandatory shackling of immigration detainees during court appearances, as well as on the question of prolonged detention without a bond hearing. We also have, as Kelly said, hunger strikes in immigration detention centers, both seeking to change conditions of confinement, but also trying to pressure the Obama administration to issue a moratorium on deportations. So as we think about this, right, how would the shift that Kelly seeks to make in her paper from saying immigration detention is imprisonment, how would that change the kinds of legal claims that get made? How would that change the kind of strategic alliances that people make? And I think this is a really interesting and difficult question. So Mark Dow, in his book American Gulag, which is actually subtitled Inside U.S. Immigration Prisons, right, rather than the detention centers, prisons, notes that while technically detention facilities are not prisons and INS prisoners are called detainees, factually, someone who is detained or imprisoned is a prisoner. So what are the consequences of calling immigration detainees prisoners, and what do we do about the fact that many advocates for immigrants actually advocate for immigrants by actually distinguishing them from prisoners, right? The prisoners who presumptively deserve to be there, unlike the immigration detainee who is unfairly being put in the context of prison, right? So how does that kind of parsing out of issue fit into this? And one answer might be the kind of work being done. There's an anthology called Beyond Walls and Cages, trying to think about the interconnections between contemporary immigration and penal policies. I suspect there are actually a lot of people in this audience who have other ideas, so I will end it there, and I think we're going to open it up.
Yeah. Oh, sure, yeah. No, I got it. So I think we'll open up first before you want people to, okay, oh, is somebody ready to stand up and ask a question? Yes, sir.
Question that has been on my mind for decades. How the courts and the legal system were able to transform the constitutional language which refers to person, something that could distinguish between one group of people and another, namely those given legitimacy as residents and those for whom that legitimacy is withheld. Perhaps you can tell me what the historical foundation for making that distinction with constitutional language has been.
Well, I think this is a question for Leti, but my understanding really is that there are constitutional protections for persons, and there's a separate set of protections for citizens, and that's fairly clearly articulated. Would you put it another way?
Citizen only refers to election campaigns.
So,
Everything
yeah.
else refers to persons.
Yeah, so, I mean, so basically, I think what is going on here is what people do in the field of immigration law is they say there's a distinction made between what people call immigration law and alienage law, right? So alienage law refers to what you might think of as territorial personhood. And so the case of Yiquo, the Chinese laundries being operated in San Francisco, the Supreme Court says, yes, these aliens are persons. They're physically here. While they're in what we could think of as the soft inside of their presence here, we do want to give them some kinds of protections. At the same time, there's something called immigration law, which, as Kelly says, is governed by this thing called the plenary power. This is when immigrants are not treated in their daily lives in terms of the territorial presence they enjoy, but in terms of the regulation of their movement, their entry and their exit in and outside of the United States. In this context, they have extremely limited constitutional protections. And so, these are these early cases that set this up that Kelly was talking about, Che Chen-ping, EQ, and then Fong Yue Ting, where basically the court says, because these are issues involving the regulation, the movement of immigrants in terms of exclusion and later deportation involves international relations, foreign affairs. These are very sensitive political questions. We want to give the political branches of government, basically Congress and the executive, incredible deference in deciding how they want to do this. And there's very little room for the judiciary to navigate this. So then when individuals started bringing claims saying, I'm a person with protections under the Constitution, they basically said whatever Congress decides, whatever the executive decides as to you is due process. That's the due process you get as an alien in terms of the regulation of your movement inside and outside. So anyway, just to say, like, there are protections as persons that non-citizens get, but this is governed by alienage law rather than immigration law, and so there's this kind of bifurcation that gets made.
In other words, that distinction was made in Congress and not in the legal system.
No, the courts carved out this distinction with a series of cases, and I can give you afterwards citations or scholarly writing about this bifurcation to help explain. Okay. Yes. Mm-hmm.
So I just was wondering about kind of how the story is constructed, about the necessity to hold individuals while we decide what to do with them. So I know that a lot of the story around Chinese immigration at the time was really gendered, and it was about how there was this population of men who didn't have women there to sexually partner with, and were luring white American women, perhaps in San Francisco, into opium dens and these kinds of things. So I just wanted you to speak about kind of differences that might have changed the outcome if we were talking about, say, a group of people who we were keeping from using resources. Like, we're going to lock them up to keep them from going to school and to the emergency room until we figure this out, versus we're going to lock them up while we, to keep them from compromising our white women. And keep everybody safe. So how that might have structured the outcome.
Well, it's a really great question. And I think that what is really instructive here is because there weren't really arguments about immigrant detention, we don't know the discourse that they were using to legitimate confining immigrants while they're awaiting deportation hearings in this time period. But the late 19th century in this region and across the country is an incredibly mobile period. Everyone is on the move. So it wouldn't surprise me if that would have been an argument that was made. But we don't know, and we'll never know what the logic of that moment was deep behind this sort of aside in the decision. And I would argue that's really a reason to rethink it and return to it and wonder about the decision that was made.
I'll just quickly add, I mean, there's this, today when you think about immigration law, the idea is, well, why do you keep somebody in detention rather than release them with a fair bond hearing? It's basically, are you a danger to society or are you a flight risk, right? So will you actually show up for the removal proceeding? And, part of the issue is that now there are like these vast categories of people who don't get the opportunity to show that they individually, right, are not a flight risk or a danger to society, but they fall into certain categories because of their purported criminal activity or because of how they actually came to the United States, right? If you show up and you don't have papers or you have what seem to be false papers and you want to challenge this, you're going to be put in detention, right? So there are lots of people who are asylum seekers who are actually being mandatorily detained. The New York Times just profiled these Tamils in Miami who've been in prison for 3 years, right? But anyway, I think, I know Kelly knows Nayan Shah's book, Contagious Divides, I think is a really useful resource in thinking about historically that construction of how early Chinese immigrants were considered deviant, and definitely non-normative sexuality in terms of, you know, that they're deviant because they don't have access to these women was part of the narrative that was going on.
I'm in the back.
Sorry, thanks for your talk. It was really great. So I guess my question is, you focus primarily on the Chinese population. Could you put it in a bit of context, possibly, speaking about how some other populations were treated out?
Well, yeah, what is really quite striking about this, and I think Leti sort of indicated that in the larger paper, there is a section on that this is a set of legal decisions that is derived around Chinese immigration, but very quickly is turned and used against other populations. In particular, in this time period would have been European contract laborers who become subject to deportation and immigrant detention. So Ellis Island, which is established right in this time period, very quickly goes from an immigrant port into the United States to a carceral facility, a detention center, a prison, cage, whatever terminology you want to use. So these sets of decisions are changing the entire immigrant experience in the United States, even at the moment, and certainly across time.
Professor Hernandez, many of my friends in the history department tell me it's discourteous to invite a historian to speak far beyond the bounds of the historical period of their talk, but you invite it by virtue of the repeated reference to the enduring legacy of the cases that you've spoken about and the continuity to, between the history you've charted for us today and where we are today. And so I'm wondering if you can speak a little bit more about why were these so enduring? Why was this legacy so enduring? There are plenty of things. Well, I'll just leave it there. Can you just tell us why you think that these such an enduring legacy? Why was it not a discontinuity?
Why was it not a discontinuity? Well, there are a variety of changes, of course, that happen over time. But in terms of this being an unchallenged set body of law and decisions, I would argue that as you move into the early 20th century, you have really a changing discourse about immigration to the United States, where prior to that period had been much more the nation of immigrants discourse about entry, except for these very much more narrow populations. But as you move into the 20th century, the discourse of immigration control and immigration exclusion and deportation become much more powerful into the tribal 20s. That logic sets in that this is a rational way of behaving in the nation of immigrants. So I would sort of make a broader social cultural analysis of that. Maybe you have some insight into the legal challenges that may have happened.
Actually, I was just thinking of Donna Gabachia has written a piece tracing the nation of immigrants. She actually says that earlier it was a nation of immigrants with an E, right? So there's a notion of all these Europeans are coming and like making this their home. So, which is just buttressing what Kelly was saying, in the sense of other than this kind of the strange phenomena of the Chinese, right? You have in general the sense of openness, right? But I guess Erica Lee also, in her Gatekeeping Nation, talks about the Chinese as creating this kind of legal architecture that then gets set and used. So all these kinds of techniques of surveillance and monitoring appear for the first time with this particular group of people, and then they just become part of this bureaucratic apparatus that then is set up, and Kelly talks about this in her paper as well, that this apparatus then gets set up that then is used and deployed against other groups of people.
Yes, right here.
So thank you very much for your fascinating talk. So at least some of the discourse in the 19th century about the prison and the penitentiary is that it's about turning people into better citizens and scrubbing roads free of their resistance, making them docile, useful citizens. There's sort of a story about that. And one might, from that point of view, think that there should be that deportation and the prison should be sort of opposite tools for different populations. The prison for people you want to integrate ultimately into your domestic population, the deportation for those that are unassimilable or you demonize so much they have to be removed. So fascinating that at this moment they conceive of them as a joint apparatus, right? That the prison not just as a way station on the way to deportation, but as a distinct moment. At least. Do you have any thoughts about that?
No, that's an interesting observation in terms of the prison had been a place of reform and reintegration, rehabilitation, bringing people back into the society, and with the rise of deportation, it becoming a center of expelling people from society. Within that, you've got another sort of set of prison as a social microcosm, and that is the Southern prison, right? Which is not about rehabilitation and bringing people back in. It's about labor control, mobility control, and disfranchising the largely black working class. So all of that is happening here, and what is so fascinating to me is the incredibly diversity of projects that are going on around imprisonment at any given time. And for me as a historian, one of the jobs is to sort of lift up all of these different stories that are happening. So I really like that observation that you have.
I'm also wondering, and Jonathan might know this, but just thinking about the financial mandate for prison, right? So you've got the southern roads. I mean, like all the roads in the south that are basically constructed through convict labor, and how the financial imperative for prison labor, how does that, is that temporarily later than coinciding with this notion of prison as an opportunity for meditation on one's sins and reform? So thinking about like prison and prison labor and how these things connect.
Well, in terms of the convict lease system,
Yeah.
the road gangs that build the roads are, in an odd way, according to Liechtenstein and others, a kind of modification of the southern paradigm, a little bit toward the correctional. The idea that this will make good citizens of these roads, by building the roads.
Yeah.
In the back, yeah.
So perhaps I misunderstood that when the
Geary Act.
when they were pushing for that, what I thought people originally were upset was that they were placing upon the Chinese community this burden that other groups didn't have to prove citizenship or prove they were supposed to be there. So it's like the indignity of making this group do this. But then it seemed the court cases focused more on deportation. Was it that always the issue, or it's just part of the indignity of or what was happening from the beginning?
Well, no, certainly. So the groups such as the Chinese Six were interested in the politics of expulsion, but also about the politics of dignity within the United States. And they're related to one another, right? So those who don't belong and can be picked up and removed, it is a blow to their dignity for those who remain within the United States. With that said, the legal strategy is one that's more about the invention of deportation as a mechanism, as a tool, as a legal practice in the United States. So it's just that you have different populations approaching the same question with different purposes. So the Choate and the legal team really take on the constitutional questions, whereas the Chinese equal rights groups are really more interested in civil rights.
So when the Chinese government was so upset over this, was it because they felt that their citizens were being protected in the country, or not so much just this issue of deportation? Or do you think both of them?
Well, so yeah, the Chinese government is another sort of player in all of this. And it would be the international politics of the standing of a nation state via the representatives of the nation within the country. That is certainly the politics that's played. You also have to understand this is the moment of the rise of the Boxer Rebellion. There is an enormous amount of tension that is going on between the United States and China and around questions of trade and religion and missionaries. So this is just more fuel to the tension that is already there.
I just want to underline that, at this moment in time, there isn't a possibility of Chinese immigrants becoming citizens, right? They're racially barred from naturalization until the middle of the 20th century. So just.
And I think I saw you next, yes.
Yes, thank you very much. Just to sort of concentrate on, let's call it the material culture, or behavior in general, was from the beginning to distinguish jail, even if there was a jail, some sort of mythicization that it's really not a jail. Who guarded them? Thank you.
That's such a good question. In immigration stations, there was an attempt to make a distinction between prisons and jails and immigration stations. So the ways in which they trained the guards, the ways in which they armed the guards, they tried to make an actual difference, saying, well, the guards at the local jail look like this, so we're going to dress ours differently. Right? That doesn't actually change the experience of the migrant, but they are aware of trying to make Ellis Island and El Paso, what would later be Terminal Island, look different than a prison or a jail. But you have to understand that the federal carceral capacity of this country was so limited until the 1930s. There really were very few federal prisons. So the majority of immigrants in detention and after 1929 who are going to be imprisoned on federal immigration charges are spending their time in jails and in prisons, where there is no distinction, certainly in this time period. It's something I noticed so much. It's like, wow, they're really working very hard to give a different meal plan this day in the detention center than they have at the jail, because they want to make sure people know it's different food. But they're still under armed guard and in cages.
So I have two questions. One, just because I'm fascinated by the story of the Chinese Six. I'm curious as to what the archives looked like in talking about the rebellion, and what were the sources, what kind of documentation spoke to this kind of really early immigrant rebellion. And then my question for Professor Volpp is, if I was struck by how comparable the Geary Act was to special registration, and whether there was any discussion, or is there any contemporary discussion of the two simultaneously?
Well, the question of the historical archive is a very good one, because I am not aware of a lot of documentation that's written in Chinese. It's all sources that have moved through the press into the archive. So this is largely based upon press reports of, for example, the Chinese Six put up this open letter that they wrote to all Chinese immigrants in the United States, and they posted it in Chinatowns across the country. And this open letter said, defy the law, this is what's wrong with the law. And then the newspapers would get a hold of that and report on it. And a variety of newspapers, those who, there were Chinese American newspapers that were developing, and there are also the LA Times, the New York Times, they were all reporting on this. So that is largely the source space that I'm using.
That's really interesting. I don't know if anybody who's written about this. It could be a great project. But I mean, one thing to think about, I mean, they're different distinctions, right? So obviously, so special registration was about people that are non-immigrants, so people who are temporarily here for specific purposes, which was a category that I think hadn't quite been invented at this point, because you were sort of here as an immigrant. But also thinking that this is something that's in the paper, but Kelly couldn't talk about. I mean, the other part of the Geary Act that's being challenged with Fong Yue Ting is this so-called white witness requirement, right? So there's, other parts of the Geary Act which, wouldn't pass constitutional muster probably today, but that were also there. But it's interesting. I mean, I know people have tried to trace special registration to this kind of mandatory registration of students during the Iran hostage crisis of Iranian students. But I think it's really interesting to think outside of these kinds of boxes in the way that you're doing.
Yeah, thank you, Kelly, for really stunning. I was wondering to what extent, Dean, you mentioned some of this in terms of the sort of white workers who are protesting for the Geary Act and things like that. To what extent, how do you see the kind of economic turbulence of the late 19th century shaping a lot of these policies? And then alongside that, how do you see, or were things like the Geary Act ever used to type of folks who are protesting at Haymarket and things like that?
Oh, interesting. Right. Well, so anti-Chinese organizing certainly follows the ebb and flow of the economy in the West. So during the terrible 70s is when you have these massive pogroms that really catch fire across the West. In Los Angeles, we had a massacre of 71 Chinese who were slaughtered and left in the jail yard. So that is following exactly the financial crises of the era. Now, with that said, I really only talked about the laborers, but capital is a strong supporter of Chinese immigration. And so that's where this tension is happening. Like, we will pass the law, but we will underfund the law, right? And there's this incredible tension within really white democracy in this time period between labor and capital. And they're finding these compromises, they're trying to poke holes in the other side, that this is not an easy story about simply the white laborers, which is really mostly what we've talked about. We've talked about Chinese exclusion during this time period. It is also a story about, I would say, largely the triumph of Western capital by underfunding the Geary Act in terms of trying to push back the stated interest of white labor at this time period. I'm sorry, your second question was, can you repeat that, David?
To what extent any of these laws were used to repress
Haymarket.
what we would now call white immigrants, but Italian folks,
Right.
Who were actively participating.
Yes, yes, yes. So the Geary Act obviously is not used against white laborers. But what's so important about the Geary Act is that a deportation law had been passed 1 year prior to the Geary Act. But it was still, everyone was unsure whether or not deportation would make it as a practice in American law. So it's the Geary Act which really establishes the legal framework for deportation as being legitimate. But immediately, what happens is, because there is such a limited amount of funding for deportation, is they go after more strategic immigrants rather than mass sweeps of Chinese or Europeans or whoever. So it's radicals, it's largely European radicals, anarchists in particular. It's almost as though as soon as Fong Yue Ting is decided, the paper the next day is, let's get the anarchists. And so it's European radicals who are the first targets, really, of deportation and contract laborers, but often they're caught on contract laborer charges. So that was something that was very fascinating, how fast it happened. Because the Chinese Six and their lawyers are so adept in every city where they try to launch mass raids against Chinese communities. Those lawyers are at the jailhouse within 20 minutes, and they are fighting to get people out of jail. The radicals is not the same story. So I think a lot of this has to do with incredible organization of the Chinese Six companies, which has its repressive element certainly to it, at fighting back against the origins of deportation. And they were quite effective in terms of everyday life. The law stayed with us, but the lawyers were quite successful in this massive resistance campaign.
Run out of time. Please join me in thanking